So Prashanto, tell me, what importance does these events like DAW hold for Indian legal fraternity?
I think DAW is extremely important because, first of all, it's an institutional step which is being taken by the judiciary itself and is being proactive. And I think that is a great message about our seriousness regarding the arbitration setup, both domestic, because the act is one, so both domestic and international. So I think it's a very serious message they give by the institutional involvement, and I think that makes it a very unique program.
Right. So how can arbitral institutions and law firm collaborate to create further checks or maybe stronger checks and balances?
Well, I think what must happen is that the law firms which are involved in arbitrations must increasingly push for appointments through institutional arbitrations. And that can be done even through the courts. The courts are very burdened, so even when there is a Section 11, etc., I think the attempt should be to use your advocacy skills to promote institutional arbitration, because that's the way forward for greater transparency. Today's thing, we were talking about fraud and party bias of arbitrators. All that can be avoided if there is a arbitral institution which is making the appointments.
What are the major key takeaways from today's discussion?
So today's discussion, I think the most important takeaway was, in fact, there were, I would say, three important takeaways. First was that corruption is everywhere. It's not just in India.
Yes.
I mean, you saw I let the speakers speak about it, the kind of corruptions which are happening, and it's similar everywhere. Second was that I think the panel, the conclusion we came to was that if an arbitral tribunal finds hints of corruption, or even if the supervising court finds hints of corruption, then the normal rules of non-interference must give way to a more inquisitorial approach to uncover the fraud. And why is that necessary? That is necessary to preserve the integrity of the arbitral process itself. The third thing, takeaway, I think, is that since public sector undertakings are involved in a big way in arbitrations, I think there should be proper selection of good representation of counsels. There should be perhaps a light vigilance touch when appointments are made on big arbitrations as to whether the person who's being appointed has the requisite experience or not. Because if the person is incompetent, then it is even more difficult for a tribunal to make out whether it's because of fraud or whether it's because of incompetence.
Right. And already there are too many challenges on the appointment of arbitrators.
Yes. So I think that importance of these public sectors making the right choices of representation. And one last thing is that arbitration is a hybrid structure between common law system and civil law system. Civil law system is more inquisitorial. Its aim is to take a more active approach in finding the truth. Common law is party-based, that parties give their representations, etc. I think this is the case where it's a wake-up call for all of us to realize that the civil law system, I mean, the trend was that I think Juan just gave a thing that common law, civil law is dead, arbitration has been taken over by common law. That's not the case. Because if you want integrity in the arbitral process, if you want to uncover fraud, it has to be more inquisitorial at times. And that's a civil law function.
What are the key differences you have seen in the arbitration ecosystem in India and UK?
So, well, I'll be very frank. I have not really been involved in arbitration system, domestic arbitration of UK at all.
Okay.
So it will be very difficult to make a comparison. I won't be in a position to do that. But yes, I do find that the Indian arbitration system is such that if we see the large number of domestic arbitrations which are there of varying kinds, and including involving fraud, etc. So I think it's a very rich ecosystem where you get a lot of exposure to different types of practices which are taking place, and perhaps think about those practices. In UK, the number of cases would be far fewer, and therefore the scope for being able to kind of think and work on those cases would be and kind of come to conclusion maybe less. But as I said, I'm not an expert on UK ecosystem of arbitration.
You have been a part of DAW since beginning. So how have you seen this evolve over the period of time?
In fact, I'd say that DAW has had a unique identity from day one, and that has remained the same. It's not really, it hasn't really required much evolution. 2 or 3 things about DAW which are very, very wonderful. One, the programs are well spaced out.
Right.
It's not multiple programs and this. So you're not running around and under tension for choice and for, missing out good speakers. Networking also is a part of the process. You're missing out on that. So that is one. Second thing is, it's a very congenial, convivial environment. I mean, if we see the law chambers which are there, they are inviting each other. There is arbitrators, lawyers, there's a whole merging which is taking place. Judges, retired judges, sitting judges, they are participating in this entire thing as learners, as people who want to improve the system. So that collaborative spirit is wonderful.
Right. If you have to define
Bye.
If you have to define Delhi Arbitration Week in one word, what that would be?
I'd say unity in diversity.
Lovely. Thank you so much, Prashanto, for
Thank you.
giving your
Thank
time.
you, Bhumika. Thank you for taking this interview.
Lovely. Thank you so much.